was applicable in this case. No, my lord. I'm not disputing the direct literal translation. We had quite a vigorous debate about if it was intended as a greeting, why it was not written in isiZulu. And then we had a discussion about how the phrase "we see you" had been used by the accused in other social media posts, and how we
Yes. And correct me if I'm wrong, but on this one, I stand. Brigadier Steinberg, who testified here, to exhibit. Sorry, Mr. I'm soliciting the assistance of Mr. Moore. And that's supplement. She said, Sambudla's use reference to the word Sambudla, and by seeing you being. The explanation by PhD in her emotional in the hierarchy. Sawubona. I have a special affection for this greeting. In South Africa, where I'm from, it's the Zulu way of saying hello. The word itself it recognizes the power of that seeing. It is our relationships with one another, our mutual acknowledgement, that brings us into being. You agree that this is in line with what I had put to you of the rich meaning? Again, I accept you.
The terminology that we use on social media, things move very, very fast. So I think that now that, while it may still remain the literal translation, would be an outdated translation.
I see. So is that a serious answer? So you think the word South has changed in the last 1,000 years, or in the last, since 2016?
No, my lord, what I'm saying is that I have absolutely no dispute that the literal translation into isiZulu of "we see you" is Sawubona, but despite a lot of the content which has been canvassed in this courtroom from the social media of the EU has adopted a totally different meaning in social media culture, not just in the South African context, but internationally. "We see you" now has a very particular meaning on social media and indeed in popular culture. And in paragraph 15 of my report, I canvass what I believe to be the meaning of "we see you." The accused did not write the term in isiZulu, despite in just about each of the tweets using other isiZulu phrases, for example, amandla.
Okay. Would you agree at least that what I just read out to you is not merely a translation? It's a deep philosophical interpretation of the phrase. There's a difference between translation and interpretation. Would you agree with that?
Yes, my lord. I think it's a beautiful interpretation as well.
Thank you. That's all I wanted to agree on. That this shows meaning. All right. Then that was just a preface. By the accused, "we see you" or "Sawubona" or that expression, it has a connotation of violence. My theory is that it doesn't, obviously.
My lord, I have never said that "we see you" has a connotation of violence. My evidence and gratitude.
But your theory, maybe I paraphrased it badly, and forgive me if I did.
tweets discussed in this courtroom.
Yes. That's exactly the crux of my question, Ms. Sadler, and I'd like us to just deal with that. Remember, I'm going to argue at the end of the case that your theory of associating the phrase with violence is wrong. You don't have to agree with me. Yeah.
And encouragement of violence, but not only. It's used in a whole different range of ways, but always for me, coupled with admiration, recognition, and gratitude.
But here we are dealing with a specific case. We can't just... So in this instance, in your evidence, what are you telling the court? What was this phrase?
Go to that section of my report, which is exactly what I'm saying in answer to the same question.
So what are you making of the phrase before this court?
The phrase "we see you" is used in the context of the accused's social media accounts. Of some of the tweets depicting violence, that recognition, appreciation, gratitude is of violence. But sometimes it's of other things.
Is that no. Anyway, the record will speak for itself. That's not what I was saying to you. Let me try again. I'm saying, madam, that to the extent that you say that was using that phrase for anything to do with violence, whether it's all the time or some of the time and so on, that's a different matter. I'm going to demonstrate to you now that that theory is false, or rather that I'm going to argue at the end of the case that and now I'm going to demonstrate to you why I'm going to argue that. And let's start with the one which is easy, because it looks like we're going to agree on it. On page 63, you agree that the phrase "we see you" is used in a manner that has nothing to do with violence.
Yes, my lord.
Thank you. And it's used by this accused.
Yes, my lord.
Thank you. Now we're getting somewhere. And if you go to page 56 of Exhibit J, my lord. By here, that phrase has absolutely nothing to do with violence.
Yes, my lord.
Thank you. Then, and I think, to be fair with you, I think we did agree on this, but I'm just recapping. It says on 7 July 2027, DZ local media reports that roads in KZN have been blocked by Truckers and Taxis Association protesting against the sharp increase in fuel costs. And then she tweets, "Welcome KZN, we see you, Amanda," 3 fists and 3 exclamation marks. You would agree that that does not defeat any violence?
Yes, my lord.
Thank you. All right. So, and you agree that those usages by her were after 2016, when the meaning of Sawubona had apparently changed, correct?
My lord, that is not an accusation of what I said. I never said. Mr. Mpofu is putting words in my mouth and twisting what I said. I said that the English phrase, "we see you," has changed in the last 10 years, the way it's used. I never disputed that the translation of Sawubona has changed in the last 10 years.
Fair enough. Okay, I apologize. So let's confine ourselves to the English phrase. Would you agree that
use of the phrase "not attached to violence," where the accused tweeted the day Russia invaded Ukraine,
sure.
"We see you and we salute you," leadership, Amandla, 3 raised fist emojis, 3 exclamation marks, and a photograph of President Putin. In nowhere in my report, my lord, did I say that the phrase "we see you" used by the accused is always attached to violence. It's always used as a recognition, admiration, gratitude, identifier.
Thank you. So, whether, okay, one thing we know is that it's always used for the things that you've agreed. And according to you, it's sometimes used in association with violence.
Yes, my lord.
And other times, as we've now indicated, it's used for something that has absolutely nothing to do with violence.
Yes, admiration of people, for example, my lord. Yes.
Thank you. That's all I need here. Thank you. Thank you, my lord. Those are the questions that I wanted to I'm indebted again to the court for the opportunity and to my learned friend. Thank you.
Thank you, Mr.
It's usually 15 minutes, 20 minutes.
So you can come back half past.
That's
Court will adjourn until half past. Court will rise.
Ma'am, you have now clarity, and please just listen to the questions carefully and answer to the best of your ability. So during your cross-examination, His Lordship made a comment at some point when there was a discussion between yourself and Mr. Mpofu. What exactly your expertise are.
In my examination in chief, we went through the experience listed in paragraph 3 of my memorandum. And I remember, my lord, you took extensive notes. But in short, I am an admitted attorney. I have a BA LLB with distinction from the University of Witwatersrand. I am widely regarded as the expert in South Africa on social media and the law. I have a company based in Johannesburg called the Digital Law Company, which advises and educates on all aspects of social media and the law. I have authored a number of books. Most recently, a book published by Penguin Random House in June of last year called How Not to Mess Up Online. I am in the process of co-authoring a new textbook, the Media Law Handbook for LexisNexis. My Lord, I was involved in a high-profile case in July last year where for the first time Meta Inc., the company which owns Facebook, Instagram and WhatsApp, consented to an order of the High Court requiring it to hand over identifying information of individuals involved in the mass distribution of child sexual abuse material. I have spoken to over 1 million children at schools around the world about social media and law and responsibility. And I advise law firms and companies on social media. and the law.
So if I can ask a follow-up question on that is, what makes you then an expert in this matter?
My Lord, this matter involves content published on social media. It's therefore squarely an intersection of my two main specialities, which is social media and the law.
Now, you recall there was a long debate even previously when you were cross-examined today, and today we started off with that again, where the suggestion is that a portion of your of exhibit J must be thrown in the dustbin, and as Mr. Mpofu is again reiterating here from the side, is that his view is actually that the entirety of it should be thrown in the dustbin. You recall that?
I do recall that.
And I want to ask you, how does the fact that the document that you prepared, Exhibit J, the fact that you term it as a memorandum and not originally prepared as an expert report, how does that affect the independence of the conclusions that you make?
It does not. My Lord, the document prepared and styled as a memorandum is indeed independent, unbiased, and my expert opinion had I been given the opportunity to turn this memorandum into an expert witness document prepared solely for the purposes of this courtroom, I would have literally copy-pasted inserted a conclusion summarizing the findings I made throughout the report.
provided you
Was not provided with any information from any evidence relating to the accused social media accounts. That I rely on in the memorandum myself, from the accused's social media account, I confirm that in paragraph 2.9 of my memorandum, I reiterate that all of the content was obtained by me through openly available information. All screenshots were obtained by me. Except in the case of the screenshot of the deleted tweet. But I did obtain the screen record of the deleted tweet, which appears on the USB I handed up, which became Exhibit 3. My Lord, the only information I was given by the Hawks was content from 3 different WhatsApp groups, which I describe in paragraph 2.5 of my report.
Were you at any stage or in any way influenced by the Hawks who appointed you or instructed you?
No, I was not. I was simply asked a question, my Lord. Exhibit 3. It is a one-sentence request. The request was as follows, and this was the only information given to me by the Hawks. The request was, with regards to DZS, the accused, in this case, abbreviation will be explained later through a call. Looking at her Twitter, can she be seen as an instigator or inciter? If yes, please elaborate. Her Twitter account was allegedly banned or suspended. Can you establish why? And the specific instruction is the last sentence of that paragraph. During month of July 2021, please look at her posts on Twitter and advise if there is any legislation that was violated. So to confirm, all evidence contained in my report was obtained by me from publicly available sources.
I don't want to interrupt the reference, and I don't think he is trying. All the evidence
as far as partisan. Can she comment on that?
While I was by no reason biased in this case. In the expert by the as being biased and partisan, the main reason for that appears to be the allegation that I styled my report, memorandum, on the evidence of Sarah Jane Trent's complaint. My Lord, the first time I knew that Sarah Jane Trent was even involved in this trial was when I read the defense expert report a few days before coming to court in November 2025. I have to date not seen sight of that complaint, or indeed any other documents in the docket, except for when I was handed this morning, I don't know her title, Mrs. Steinberg's report, and I had sight of the first 2 pages. Other than that, I came at this matter completely independently and relied only on evidence that was available on the accused's social media account and remains available on the accused's social media account.
You mentioned now that the defense experts. I want to ask you, in the defense expert report, the expert there, well, the court will determine whether he is an expert or not, is stated that you failed to comply certain standards in compiling your report. Do you recall that?
Yes, my Lord.
And you stated that those standards were not relevant to your analysis. Is that correct?
Yes, my Lord. They're not applicable.
Can I ask you to clarify why you say it's not relevant to what you did?
My Lord, the report compiled by the expert for the defense
That is Exhibit H1.
suggests that various standards, and if you give me a second, I'll find the paragraph. Are required to be met in order for electronic evidence to be accepted.
Apologies, my Lord, I just want to see if I can quickly get to it. If you look at page 84 of H1. Apologies, that refers refers to the CSIR.
So what is your answer?
My answer, my Lord, is that those international standards, the ISO, IEC standards around metadata, are only triggered if evidence is in dispute. For example, if content had been deleted as to whether the content ever existed. Particularly these days, my Lord, with deep fakes and AI technology, you can't always rely on a screenshot as being a true reflection of online content. In this case, those standards are not triggered because the content remains live on the accused's social media account. Any person in this courtroom, or indeed any person with an internet connection watching online, can go to the accused's Twitter account, X account, and find all of the tweets referred to in my memorandum on her account. If you have a look at page 80 of the defense's experts' report, the very last paragraph of that page, page 80, Mr. Tsibolane says the state relies solely on screenshots, which under Section 15 of ECTA and case law are admissible, but carry limited evidentiary weight absent corroboration. My Lord, this evidence is corroborated by the live content which is still available. On the accused's social media account.
No, I don't. Can I proceed now? I just want to quickly deal with if this of was referred to, you might need a bigger reference to case.
My Lord, a lot of legal content in the expert report of the defense.
Even if you look at page 86, 87.
And indeed the conclusions. 86 and 87 are the case law used. There are legal findings throughout. Bear in mind this is from somebody without any legal background. I believe Mr. Tsibolane is a lecturer in information systems.
Can I ask you, whilst we dealing with Exhibit H1. Can you turn to page 8 of Exhibit H1? That is now Mr. Zulani's report. Are you there?
I am, my lord.
If you look at there, the export, it says there's sort of in the middle of the page, it starts off by saying this expert report seeks to. And one can assume that was what he was required to do in this report. Is that correct?
Yes, my lord.
Can you perhaps just read point number 4 into the record that's written there?
Yes, my lord. Point 4. This expert report seeks to, number 4, assist the court in understanding why, from a forensic information systems perspective, the alleged causal link between her posts and acts of public violence cannot be proven beyond reasonable doubt.
Now, would you agree with me that that is a function of the court, not of the expert?
Yes, my lord.
So, if it is suggested to you that you are partisan, do you have any comment with regards to this report that is before court in terms of, or as marked as Exhibit H1?
My lord, at the very outset of the so-called Rolls-Royce report, we have a pre-finding from the lecturer in IT systems about causation and about the beyond reasonable doubt. I indeed highlighted it with many asterisks, that this made me nervous right at the outset. If we go to the next paragraph.
But before we proceed, Mr. Mulman, so that we are all in the same picture, what exactly is happening? Are you attacking the admissibility of that witness report evidence so that we're in the same picture? What exactly is happening?
I believe when Advocate Ganga was dealing with the matter, he placed on the record that obviously this is the admission of this exhibit will be subject to the witness coming to testify, and it will be. I'm just giving this witness an opportunity to express her view on this report, just as the defense witness, if he is called, has been given the opportunity to comment on her report, as well as the purpose of the questions is to demonstrate the issue of being partisan of this witness, as opposed to it sort of being suggested to the witness that the defense report is a non-partisan, and he actually has a paragraph in this report stating that he's not non-partisan.
So are you, I just want clarity, question for reasons of perhaps doing what? Objecting to the admissibility of the report itself, or I'm not saying refrain from your question, but I want to understand where are we?
My Lord, at the end of the day, it goes down to the weight that the court will eventually attach to this report.
No, thank you.
I did digress a bit from my initial line of questioning, so let me just go back to, we were talking about the standards that you did not apply according to the defense expert. The question is, does the fact that you did not apply those standards to your analysis, does it affect the reliability of the conclusions you came to in Exhibit J?
Not at all, my lord.
During your cross-examination, you also repeatedly said that the media posts, by that I mean the Twitter content of the profile, Twitter profile of the accused, must be looked at in context. Can you just clarify to the court what you mean by it must be looked at in context?
Sorry, I'm jumping around a bit. I was going to answer, we were going through, do you mind if we go back to page 8 of the report that you were just asking about? Apologies, because the context question, is that okay?
See?
So we were just going through the executive summary of Mr. Tsubulane, and the core opinion, in brief, he posts just below what I just read into the record number 4, says the matter originated from an advocacy-driven complaint lodged by Ms. Sarah Jane Trent, which contained presumptive language of guilt and untested assumptions and causation. This framing directly influenced the later Digital Law Company and CSIR analyses. I do just want to reiterate, any of complaints. The entire premise of experts is that, which is my report, he accuses it of being biased from the outset on the basis that I, in layman's language, copied what had been included by Ms. Trent in her complaint,
So is that,
which is not possible.
That still answers your question. Your question was the fact that you did not apply the standard. How does the fact that you did not apply the standard affect the reliability of the report? That was your question.
And then the witness just asked if she can just go back to page 8 to clarify something further.
Yes, I still want to hear what is the answer to this question.
Ask the court, please, my lord.
What is the answer to the question?
The question was, if I can repeat it for you, does the fact that you did not apply those standards affect the reliability of the conclusions you came to in Exhibit J?
Not at all, my lord.
My follow-up question was then, you repeatedly said that the media posts of the accused must be looked at in context, and I want you to clarify to the court what you mean by context.
Thank you, my lord. The context of the accused tweets, from a time point of view, was that the accused's father, the ex-president of South Africa, Jacob Zuma, was arrested just before midnight on the 7th of July, 2021. As has been extensively canvassed, the arrest triggered widespread rioting, looting, and public violence. The violence has largely been described as the 3 deadliest days in South Africa's democratic history, with over 350 lives lost and estimations of up to 50 billion rand in economic harm to the country. It is therefore not possible to look at the tweets posted by the accused on the 9th and 10th of July in a vacuum. A, from what was going on in the country, but in particular in the KZN province. But moreover, the context to which I refer is that it was not one tweet, but a series of tweets in a 36-hour period. We agreed that there were 28 tweets from the accused in that 36-hour period. Primarily reflecting encouragement, jubilation, and celebration of the unrest.
You also mentioned during cross-examination that you regarded the accused as being an influencer. You recall that?
I do, my lord.
What do you mean by the accused being an influencer?
My lord, the accused is not an ordinary member of the public. She is political royalty in South Africa. As the daughter of former President Jacob Zuma, she has a significant following on social media. Indeed, on Twitter, she has over 360,000 followers. The accused's Twitter account is public, which means that any person with an internet connection, even if you yourself do not have a Twitter account, can access all tweets posted by the accused.
How does that aspect, that the profile is publicly accessible to anyone with an internet connection, how does that affect the potential reach and impact of a content?
My lord, the reach of content can be exponential. If you have a private account, content can only be accessed by people who follow the account, who have been approved to follow the account. I use, my lord, as an example, on page 59 to 61 of my report, where I look at the fact that the accused has a large following and is indeed an influencer, somebody that is looked up to by many. If you have a look on page 60 of the report, there is a tweet which was until November 2025 pinned to the top of the accused's account. It is a picture of President Putin, and it says, "President Putin, South Africa is waiting for you. I stand with Russia." The screenshot shows that it had been viewed 108,000 times. By the time I appeared in this court in November, that tweet had been viewed 690,000 times.
Just a moment. Mr. Mbof, you want to say something?
My Lord, yes, I'm sorry to interrupt my Lord and your Lordship, but I've been very patient with this fellow. The purpose of re-examination is not to lead new evidence in chief. if some Mr. Gangai didn't deal with something, that's the end of it. There's nothing that can be done anymore. The purpose of re-examination is to deal with matters that arose from the cross-examination. I don't know how this thing about influencer and so on arises from my cross-examination, because I never dealt with that. So Mr. Mulman must just know that to the extent that he wants to raise any new information, I have a right to cross-examine him on it, or he must stick to the purpose of re-examination.
Mr. Mulman, coincidentally, when Mr. Mpofu stood up, I was already saying something. I wanted to know whether the issues that you are putting or the questions that you are asking are questions that arose from the cross-examination. I just wanted that clarity, but now Mr. Mpofu is coming up with a very same issue.
You will recall that the question leading to this answer by the witness was Mr. Mpofu asked the witness whether the accused before court is a youth.
As what?
Or a youth or young. And then they said it's not a trick question, or it is a trick question, and then the witness responded by saying she considers the accused to be young and she is an influencer. So my question is for her to clarify what she means by the accused being an influencer. So it's an answer emanating from a question asked by Mr. Mpofu.
No, I just need a clarity on
That's
that.
the
You are now clarifying that.
Thank you, Madam.
But if you can just stick on issues that arise from cross-examination, of course, you'll know how to do it. Then proceed, Mr.
As the court pleases, my lord. Thank you, my lord. I'm going to move on. There was a hypothetical scenario sketched or put to you that if the accused made 30 tweets and other tweets were 30,000, then the contribution, her contribution would have been negligible. Do you recall that scenario that was sketched for you?
I do, my lord.
And so my question is, can you comment on whether it's the sheer number of tweets that a person makes, or threshold of incitement being met?
My lord, the discussion that I had with Mr. Mpofu
With Mr. Who?
with Mr. Mpofu in my cross-examination,
Oh, I thought you said you had discussion with Mr. Mpofu. But
the
now
exchange in your lordship's courtroom,
Yes.
as a result of questions put to me by Mr. Mpofu,
Yes.
was on the sheer number of tweets. And my recollection is there was something about a bag of potatoes. And if there were 30,000 tweets from one person, would that then if it was one or two tweets? Now, the thing about social media is that you can quite literally talk to an empty room. You can have an account and tweet thousands, tens of thousands of times and get absolutely zero traction or viewership or engagement with that content. The accused in this case has a vast following. Because of the size of her account, and by that I mean the number of people who follow her, but also because of who she is in the context of her father's arrest, her content would have had a significantly greater impact. as can be seen from the screenshots I captured, in terms of how many times content was retweeted and responded to.
Yes, Ms. Mulma.
Thank you, my lord. And if I can take you to page 47 of Exhibit J, paragraph 7.55. There.
Sorry, paragraph?
7.55. 7.55, my lord.
Thank you.
On page 47 of Exhibit J.
Yes.
Now, during cross-examination, again, you stated that that tweet by the accused must not be seen in isolation, and that the use of the phrase "we see you" was thematically the same as in other tweets. You recall that?
Yes, my lord.
Can you explain to the court what you mean by thematically it was the same?
Thematically it was the same, my lord, because the series of 28 tweets in that 36-hour period predominantly followed the same format. An area, in this case PMB, Pietermaritzburg, then the words "we see you," exclamation mark, then the word Amandla, 3 raised fist emojis, 3 exclamation marks, and the hashtag free Jacob Zuma. My lord, that is the formula that was invoked by the accused in just about all of those 28 tweets, and indeed some tweets in later years. And while I agreed with Mr. Mpofu that the media attached to the tweet in paragraph 7.55 did not depict violence, it did depict a seemingly blocked road colloquially referred to as the cool music.
But what is your answer to the question? The question is, you have said that the word "I see you" should not be seen in isolation, and the State Council wanted to know what you mean by that. So what is your answer to that?
The answer is that the tweets, the 28 tweets during that period, were a series, my lord. It wasn't one tweet and that was it. It was a series. And the tweets show various scenes from different towns all over KZN. So my understanding, by using this formula, my lord, is to show how widespread the gatherings were. So Harry Smith, Mtuba, Eshowe, Cliffdale, Megacity Umlazi, Durban City, which you will remember, Ntuzuma, then Pietermaritzburg, then Moy Plaza, Mtuba, and then culminating in the tweet, which we included as...
So what you make of the word, you said the question was, you have said the word "I see you" used in page 47, Exhibit J, paragraph 7.55, should not be seen in isolation. What is your direct answer to that? The State Council want to know what exactly do you mean by that?
It cannot be seen in isolation, my
Yes.
lord. It must be seen in the context of a series of tweets that follow the same formula. This was tweet number 23 of that 36-hour period.
Thank you, may
Can I-
proceed.
Thank you, my lord. There was also it was suggested to you it was said a combo. You can't look at the text or the caption separately. You must also consider the video or the media attached to it, the picture. You recall you agreed with that?
I do, my lord.
And then you also stated, you went on further to say that one must further have regard to punctuation, emojis, and the use of the exclamation marks.
I did, my lord.
What is the relevance of that? With regards to the, if I can be more specific, so let me answer the whole thing. Specifically with regards to the punctuation, the use of emojis, repeated emojis.
So the raised fist emoji is explored in my paragraph 16 on page 67. But my lord, the use of the phrase "we see you!" exclamation mark, as I said, I interpret the phrase "we see you" to be recognition, appreciation, admiration, gratitude. I believe that the exclamation marks add a celebratory, more emphatic tone. And as discussed, the emojis form two roles. The one is to act as a tone identifier, as well as being a way to communicate in itself.
Can I ask, this morning, you made a comment to say that the understanding of the meaning of "we see you" in English has since changed in if I'm using the correct word, changed in social media context. Can you maybe, whilst you're talking about that, of the "we see you," can you explain what you mean that the meaning of "we see you" has changed? Can you agree with that?
But before she answers, didn't she correct that and say that no, the word "I see you" did not change, but that the media, law have changed?
That's exactly what I'm asking you just to explain, my lord.
Yeah.
Thank you, my lord.
Lord, on page 66 of my report, memorandum, I include a few sentences around the term "we see you." You will see that I've said, according to Urban Dictionary, the phrase is usually used as a way of recognizing someone's recent accomplishment. I've said in paragraph 15.3, in the context of the accused's Twitter account, the phrase is clearly about recognition, appreciation, admiration, and gratitude. Really, in the last few years, my lord, on what we would call the social media streets, the term "we see you" is very widely used as a term of recognition, often celebration, You'll often see it in conjunction with, for example, a graduation photograph. But as I've said there in 15.3, my lord, the phrase is about recognition, appreciation, admiration, and gratitude.
We also asked about content moderation policies on the various platforms, and you indicated that that's a field where you have exceptionally a lot of experience. Is that you recall that?
Yes, my lord.
So in terms of users specifically of the platform Twitter, what would be the obligations of a user as it relates to the policies of Twitter?
My lord, when a user creates an account on any of the social media platforms, they tick a box saying, I agree to the terms and conditions of this platform. Now, the reality is that those change frequently. From a policy and content point of view, I did include in my report a brief analysis of the policy relating to violence and glorification of violence on social media, on Twitter. That policy changed from when the tweets were initially posted to when I prepared the report to now. So, I'm just finding the section, my lord. It's paragraph 5.8 on page 6 of my report, that Twitter frequently changes its various terms and policies.
If I can ask, maybe, so the question is, what is the obligation of a Twitter user with regards to those policies?
So, in theory, the obligation of the user is to comply with those policies, and for the platform to take action against users who violate those policies. Now, if I take you to the expert of the defense's report, which is Exhibit H1, I'm just trying to find the section, but he relies on the fact that, here, page 70,
Just repeat that. Is it
page
70?
70, 70,
70. Thank you.
the defense's expert says in the second sentence of his paragraph 8.1, the purpose is to explain why platform-level non-action constitutes independent, technologically mediated evidence that the material did not meet recognized thresholds for incitement, glorification of violence, or coordinated harm.
Ms. Sattler, I think I have to direct the proceedings. While I don't want to interfere a lot, but at the end of the day, I have to make sure that the proceeding proceed without including a lot of other issues that might not be relevant. The question was, what is the obligation of the Twitter user? Am I correct, Mr. Moore? Then the answer was to comply with policies and for the platform to take action against the users. That was the answer. So now I'm not sure what you are talking about.
My Lord, I apologize for the roundabout way of getting to the answer. The answer is that X, particularly now under the ownership of Elon Musk, is absolutely useless at enforcing any policy on their platform. The idea that because X's content moderation policy was not used and triggered, according to their expert, means that it was not viewed as harmful by independent non-state experts is, my Lord, absolute nonsense and a non-starter. Now, what I said in my cross-examination was that I myself have been involved in reporting untold numbers of violations of that moderation policy to X in the most extreme matters, and nothing was done.
Can I ask?
Mr. Mpofu.
A lot. With the greatest respect. How does this arise from the cross-examination? I'm not asking this witness anything to do about Twitter's moderation policies and whether Elon Musk is useless or his interventions constitute absolute nonsense, assuming that kind of language can be used. How does that arise from
Mr. Molman?
My Lord, it was indeed suggested to the witness, as she's now said, that it was put to her that the defense expert says, due to the fact that if content was not removed, it means that it didn't incite violence. It was specific. Apologies. It was specifically with reference to the moderation policies of the platforms. The record will speak for itself.
Indeed, well, the record will speak for itself, but unless it by memory.
Anyway,
the fact that it might be in the expert's report that I'm not disputing, but that I raised it under cross-examination.
Yes.
I'm not going to take it further, but it was suggested to the witness that therefore, if a post was not removed by the content, it means that it was not harmful.
Yes, but the horse have bolted because we have dealt with that now. And the witness have said that in terms of the policy, the platform must take action. But his or her opinion is that now that platform has become useless, they don't take action and so on. Can we then move forward and proceed?
You recall it was also suggested to you that the accused cannot be responsible for where her post would have been shared on different other platforms. Is that correct?
Correct, my Lord.
The Twitter platform itself allows for a tweet to be shared. Is that correct?
Correct, my Lord.
Now, who is ultimately responsible for that sharing of the tweet?
My Lord,
Apologies, can I maybe just, I apologize. Perhaps the one part should be sharing it on Twitter itself and sharing it on a different platform by someone else.
My Lord, the analogy put to me in the cross-examination was, if I create content and somebody else puts it on a billboard, am I still responsible for that content? The answer is that the original publisher is responsible for that content. And what I said under cross-examination is, the example that I used was Zapiro, the cartoonist. He creates a cartoon and somebody else amplifies that content by sharing it from his social media accounts, placing it on a billboard, sharing it on WhatsApp groups, publishing it in the newspaper, the authorship of that content still belongs to Zapiro. In the same way, a tweet can be shared both via a screenshot and via a share link. And therefore, that content can reach not just the people on Twitter, but on other platforms as well.
Okay, we can move on. In as far as the defense experts suggest that the linguistic and pragmatic content of the post made by the accused reflect political and emotional solidarity, not incitement or command. You stated that they do in part, and then it was put to you by the defense experts suggest that the linguistic content of the post made by the accused reflect political and emotional solidarity, not command. Follow?
Yes, I do, my lord.
And then your response to that was that they, and then as the cross-examination continued, it was put to you that you do not want to answer the question.
My lord,
So
I
just explain the part. The only part I want you to explain is they do in part.
content was, the defense talks a lot about how content has, and what I say contributing factor. The other term in part was of tweets, the big that there was no action, go and do this. Said, others to act in a manner to urge, to stir, that the incitement can be aiding, encouraging, but really it's a call for action for the viewers of the social media content to act in the manner depicted.
Can we move on to another aspect, please? You were also criticized for absence of cultural context, do you recall?
I do, my lord.
And then you said in your answer to that, that there are various forms of culture to consider, and then you listed some of them. I want you just to briefly explain to the court what you meant by them. And the first one I want you to deal with briefly is social media culture. What do you mean by social media culture, that is something that must be considered?
Yeah, social media culture, my lord, is the culture that exists in an online community. Now, the way people communicate in a community, for example, the way people behave in that community is what I refer to as social media culture. There are catchphrases that are used by natives of the social media community. Phrases like the social media streets, phrases like receipts, which would be evidence on social media, subtweeting, which would be indirect reference. You know, these kinds of elements of the community that become second nature to the digital natives within that community.
The next one you referenced was influence. apologies, influential culture.
Influencer culture, my lord, is a very
So what
big
culture?
Influential culture.
influencer culture.
Sorry, I'm typing here.
So, influencer culture is an enormous part of the internet, the power that influencers have. And an influencer, my lord, is generally somebody with a big reach who is widely followed. Indeed, there is even influencer law now.
Can I ask, the other one was youth culture?
Youth culture, so culture amongst the young. So the fact that I even referred, my lord, to a definition from the Urban Dictionary. Most parents would be very familiar with the Urban Dictionary. When their teenagers start speaking in a language they don't know, what does this word mean? They would have a look at Urban Dictionary, which is an online dictionary, largely containing phrases used by the youth.
I believe the last one was online activism culture.
Yes, my lord. Online activism culture is very often referred to as cancel culture. But it's when the online world, social media, is used for social activism. The famous examples of the last few years have been the hashtag #MeToo movement, the hashtag #AmINext movement, the Black Lives Matter movement. So it's where activism is taken from the real world streets to the social media streets.
Then there was also put to you that the aspect around citizen journalism. Do you recall that? Where you were asked whether it would be an offense for anyone just to record and report on something. My question for you is, in analyzing the profile and the content of the accused Twitter profile, what is your assessment with regards to citizen journalism, with regards specifically to her Twitter profile and the content she posts?
I do, my lord. So citizen journalism is where a member of the public assumes the role of a journalist. So news gathering and news reporting, historically, and I'm talking 14 years ago, fell really solely within the ambit of the recognized media and journalists. And what has emerged in the last decade is what we call citizen journalism, which is every person with a cell phone gathering news and publishing news. And what was put to me in cross-examination was that the content on the accused's social media account was nothing more than citizen journalism, because it depicted what was going on around the province and was broadcast to inform members of the public as a journalist would. Now, there are quite a few problems with that. The first is that journalism requires independence.
Yes.
My lord, the Malay trend purports to be asking the meanings of these phrases, such as citizen journalism, whatever. Now is leading new evidence. And all I'm saying, my lord, I'm not stopping him, but the consequences of that is that I'm going to be allowed, or rather I will be applying to cross-examining on these issues about the problems with that and all that, which is where we're going now. Whereas I thought you wanted to clarify for the court what each of those so-called cultures mean. What did you mean? That was his exact question. What did you mean by social media culture? What did you mean by this? What did you mean by this? Now we're into a discussion about the merits and demerits of something.
Lord, the question surrounding the citizen journalism follows from what was put to her in cross-examination, that what the accused did on her Twitter profile was just citizen journalism. So my question to the accused was this: what is her assessment of the profile of the accused with regards to citizen journalism? Was citizen journalism.
So the accused, the witness has commented than anything else.
Not on that aspect.
My Lord, if I can just quickly finish my train of thought, was that what was put to me in cross-examination was, how is this account different to if I walk outside court and see a fight and I film it and I put it online? That's very different.
But you can't invent just what was said to you, because this is re-examination. If State Council wants to raise that issue, then State Council will put it to you. New issues. If the issue from the defense, then the council will raise it and you just respond to it. Mr. Molman, you may proceed. Okay, you can take instruction from your partner.
My Lord, can I ask, I say it's just 5 minutes to 1 o'clock. I want to wrap up the examination of the witness. Can we perhaps take the lunch adjournment at this point, then I'll just find out from my colleagues if there's anything else they want to cover, and then we can finish after lunch.
We all agree.
No, I have no objection.
We are done.
Thank you, Madam.
Mr. Mbofu.
No, no, yes. Actually, it's the state that's supposed to tell its next witness. So I think maybe Malena should talk first.
What does he say about this?
No, he simply said he's done with, I don't know, with this witness or with the whole case.
Just with the witness before court.
Okay, thank you. Let's cycle. For me, it's just question for clarity regarding your. I don't doubt that you are an expert, but the role that you play in the matter that is before court is quite very important to know precisely what role did you play. So you said you were instructed by DBCI to look at DZS Twitter. Then what was your role? The information that is before court today, is it as a result of your own investigation of the matter? What is the situation?
Thank you, my lord. Yes, the memorandum or report that is before court is a document containing my findings as a result of the investigation that I did on the request of the DPCI.
So you conducted investigation on request of DPCI?
Yes, my lord.
At the time then you conducted that investigation, if I was trying to look through your evidence, it was not then an expert evidence, it was just an investigation to assist DPI.
Yes, my lord. It was a request to conduct the investigation with a view to becoming an expert in the trial. That was made clear to me from the first meeting, was that they were looking for an expert in these matters who could perform the role of an expert witness at the trial.
But your term of reference was to establish whether the accused before court, whether the conduct of the accused before court constitute incitement or instigation. Your mandate, what precisely were you required to? When I read the notes, it seems as if you said you were required to look at the Twitter and then advise whether that constitutes incitement or its instigation. Is that correct?
That's correct, my lord. When I was initially approached by the DPCI, which was initially in October 2022, there were two wanted my expert input on. The one is a totally separate matter, which was what I referred to as the WhatsApp groups matter, which was where they'd given me content to the July 2021 unrest and violence, but it was a separate matter entirely. And so that was the one mandate, although the meetings were combined initially to talk about both matters. The second part of the mandate was to look at the accused's social media conduct and content and give an opinion to the DPCI on whether or not I believed, given the legal framework and the available content, there was a case to answer. I concluded that there was. And it was always my understanding that if they did arrest the accused, which they went and did, and if she did have her day in court, that I would be called as the expert to give evidence. The one issue which arose and has really dominated a lot of my evidence was the written statement, report, memorandum. Had I been given an opportunity to change it, as I said, my findings would have been the same, the opinion would have been the same, the methodology was the same. It was simply a question that they didn't come back to me, my lord, and I'm not sure why that happened, but they didn't come back to me and say, okay, now it is going ahead. As discussed, you are going to be the expert. We're going to now need to include this document in the docket. That step didn't happen, and I'm not sure why not, other than to say that the prosecution presumed that the memorandum as it was originally presented was sufficient.
You also mentioned that there were deleted photos, and it's you who traced those deleted photos. How did you trace them?
My lord, there was only one tweet which was referred to in a lot of media reports when I went and I did this investigation, which was the tweet that we looked at in detail, which contained the poster for the ANC, the election poster, with Cyril Ramaphosa's face. And initially I had to rely on screenshots for that tweet because it had been deleted. It was the only tweet of all of the tweets that I discuss in my opinion that I couldn't see initially. But before I appeared in court in November, you will recall, my lord, that I submitted a USB under Exhibit 3, which contained that one deleted tweet as a screen record published by a third party. It's in the USB of the tweets posted on the 9th of July. If you would like, my lord, I can get a better reference for you.
No, all what I wanted
But
to
that
know.
was the only one, my lord, that wasn't available when I initially did my investigation.
Thank you, Ms. Sattler.
Thank
I'm
you,
not
my
sure
lord.
that there's any issue arising from the re-examination.
Yes, there is. Thank you, my lord. Okay, Ms. Sadler. At this stage, I'm allowed to ask the questions which arise from the court's questions. I just want to clarify this as well. It's your evidence that, well, let me put it this way. Well, now it looks like at least we're all agreed that the memorandum you wrote was not intended for this court, correct?
In its current form, I thought that I would have the opportunity to turn it into what looks more traditionally like an expert witness report. I did, my lord, think that the majority of the content would appear inside a court, but in a slightly different format.
Can you just answer the question, please, ma'am? Are we agreed that the memorandum that is before this court was not intended for the consumption of this court?
My lord, that's a question that will need to be discussed with the prosecution. I prepared the document for the prosecution with the intention that I would be called as an expert witness. Perhaps it was my mistake or my misunderstanding, that I would be given an opportunity to submit an additional statement.
Are you finished?
Yes.
Okay. I'm going to ask this question for the third and the last time. Should this court understand that the document called the memorandum before it was not intended by you, forget the prosecution, for the consumption of this court? Yes.
My Lord, I simply can't answer the question with a yes or a no. The first 70 pages, yes, and the rest of it in the format, presumably, of argument from the legal representatives. So yes, in some format, my anticipation was that the report would be used for the purposes of the court.
I see. So your evidence now is that the first 70 pages were you intended for the consumption of the court. Is that your evidence?
Yes.
Well, how can that be? Because according to you, you were asked, you just told the court that you were asked to assist with the investigation, correct?
Yes, my Lord.
And that investigation was going to lead to a decision by the police and NPA and all those things, those people, whether or not to prosecute in the first place, correct?
Yes, my Lord.
So when you did this, it was to inform that decision? Right?
Yes, my Lord.
So there was no court contemplated. The only thing that was contemplated was whether or not a decision to prosecute would be taken, correct?
My Lord, from inception, my role would be of an expert. From the very first discussion I had with the DPCI, when they came to my house and we had a meeting, and they said, what we're looking for is an expert who can give evidence on these matters. And we went through my experience, and they said, you're who we're looking for. And then there was this email asking me, as the initial step, to prepare a memorandum, which would then be turned into an expert witness statement.
In other words, as we suspect, the decision to prosecute the accused was already taken by the time they came to your house.
My Lord, I don't know the answer to that question.
Well, you cannot know the answer, ma'am. If they said to you, you are going to be a witness in court, the court can only arise if there's an accused person. Do you accept that at least?
Remember, my Lord, what I said was in that meeting there were two separate matters discussed. There had by that stage already been arrests in the WhatsApp Matters part of the mandate, the WhatsApp Matters group. Those three WhatsApp groups that I referred to in paragraph 2.5. And so I was never approached separately on the accused's matter. So the original meeting was with various members of the DPCI, and at that meeting it was discussed the WhatsApp Matters issue and the accused in this case issue.
How is that an answer to my question? Forget about the WhatsApp Matters. I'm just talking about the second, what you call the second matter. Okay?
My Lord, there were already accused in the WhatsApp Matters case, which is why my role of an expert was discussed in that matter.
Right. So, in relation to this accused, you were not anticipated to be an expert witness, correct?
If my finding was that there was a case to answer, and if it did happen that there was an arrest in this matter, then very much my understanding was that I would be called as an expert if this matter were to proceed.
Ma'am, please, this is very important. I respect your understanding or whatever. What I'm asking you is, was your mandate in respect of this accused, did it include you being an expert witness in court, in a court of law?
If the matter was to proceed, it was very much discussed that if my finding was yes, and that if there was a prosecution, bearing in mind that it was still in its infancy, this investigation, that I would be available to be called as an expert. That was established with me before I prepared the memorandum.
I see. So in other words, what the court must understand is that your procurement as an expert was done before the decision to prosecute was made.
No.
Or that the decision was a fait accompli and they were just going through the motions.
Neither of those things, my lord.
How do you know? I'm not talking about, this has nothing to do with you, I'm talking about the people who approached you. How do you know that they had not yet taken the decision?
It was discussed in the meeting, my lord,
That
that there was an investigation. There was very little information shared with me, but the meeting was first to establish what it is that I do, my experience, my qualifications, the kinds of matters that I get involved in. Once that was done, then these two separate matters were discussed with me. The first was the WhatsApp Matters group, where there were already arrests that had taken place. And the second was whether I could assist in initially helping with the decision to prosecute the accused by giving an expose on some of these very new social media platforms, the way publication works and the law. And then if the prosecution was to go ahead, if I would be available as an expert witness.
okay. The court asked you a question along the following lines. Is the information as a result of your own investigations on the request of the GPCI, in other words, to assist the GPCI, to which you said yes?
Yes, my lord.
Yes. Then, when you were explaining that question, that answer, so you said, the court asked you what was your mandate, remember?
Yes, my lord.
And your answer was assisting the GPCI with the view to becoming an expert in the trial, remember that?
Yes, my lord.
And the trial means a criminal trial.
Yes, my lord.
But at that stage, there was no criminal trial. The trial did not exist, correct?
Yes, my lord. It was a hypothetical question. If it does go ahead, will you be our expert?
I see. So it was a hypothetical question. Now,
Not in the other matter, as discussed, my lord. The other matter, there was already accused. There had already been arrests.
ma'am, please, I beg you. Can we talk about this case? I don't care, quite frankly, about the other matter. So neither does the court concern itself with the other matter. We're just talking about the case before this trial court right now. Do you understand each other?
Yes, my lord. But
Okay.
as discussed, both of them were discussed with me at the same time. So it's very difficult to entirely separate them, which is also why I referenced the other matter in this opinion.
I see. So it's difficult to separate them.
My lord, I've answered this question.
Right. So, okay, we'll come to that. Let's park that. It's difficult to separate them. Let's just finish this issue. Am I correct? Will I be correct if I argue at the end that this memorandum was drafted not for the purposes of assisting the investigation and giving legal advice to the investigators?
Yes, my lord.
Good. And if you are giving legal advice to the state, then how can you call yourself independent? Remember, sorry, let me put it in context. This whole thing happening here is the state versus Duduzile Zuma-Sambudla Zuma. It's adversarial. Understand? This one versus this one. According to you, you gave legal advice to this one. You did not give legal advice to this Sambudla Zuma, correct?
My lord, I
Just
didn't.
answer the question, please, ma'am. Did you give any advice to the accused?
My lord, I was asked a question and I was about to answer it. I was interrupted before I could answer it.
All right, then answer the question. What is your answer?
My answer, my lord, is that I gave a memorandum which included an analysis of the law. What I did not do is give legal advice to the prosecution. What I did was I prepared an independent memorandum on publicly available information with a very objective analysis of the law, the legal framework. Some of that was used and accepted by the prosecution, some of it was not. I have not given advice, legal or otherwise, to the accused.
Well, the question was, you want the court to believe, the question is, you want the court to believe that you are independent, yet you say you give legal advice, you assisted the state, you gave legal advice to the state, and you did not give legal advice to the accused. Listen, it's not me who is saying that. I'm just repeating the question. I'm putting the question what the counsel is saying to you. How then do you regard yourself as independent? I think that is the question.
Exactly, my lord.
It's just that.
I've answered the question, my lord, to the best of my ability. I did not give legal advice to the prosecution. I prepared a memorandum on what is the law, what is available, what have I seen, what is the law surrounding social media, because as discussed in my evidence at length, it's a very new
forget
area.
about now the state start from SAPS up to the prosecution. Didn't you give legal advice to, not legal advice, any advice to the SAPS? Whether there was case or not?
I prepared an independent memorandum on what my interpretation of the law is, what the framework is, and most of it, my lord, was a factual analysis of what was available, the extent of the reach, the timestamps, that kind of content.
I think you can proceed, Mr.
Yes, thank you, madam. I'm indebted to the court. So, Ms. Sadler, these things are recording you here. I asked you a question. Was your document to give the analysis and give legal advice to the state in the sense that your lordship has explained? And you said yes. Now, when the implications of that answer are being made clear to you through my cross-examination, you are changing that answer. Did you or did you not give legal advice to the state, as you confirmed earlier? What is your answer now? Your earlier answer was yes, you did. What's your answer now?
My lord, I have answered, I have not changed my answer on any question, no matter how many times it's been put to me through this very rigorous cross-examination during the course of this trial. I have not changed a single answer once. I have remained consistent. What I prepared was a document on the law, the legal framework. During that document, I made various findings. I included various evidence. I obtained all of the screenshots. The methodology of that report is contained in the report. Did I give legal advice? Did I sit down and say, you must go and do this? No. I made an independent report where I interpreted the law. I did not say you go and do this. I made various findings, and some of those were accepted by the state and some were not, my lord, as we have discussed in detail.
Right. So that long thing that you just said now, long and short is no, you did not give legal advice, correct?
My lord, unless I'm getting the definition of what is legal advice wrong, did they come to me and say, what is the law on terrorism, incitement to terrorism in South Africa? Yes, they did. How does it work when it comes to Twitter and publication laws? Yes, they absolutely did. So if that is giving legal advice, then yes, certainly, my lord, I did.
I see. Okay, so you gave legal advice, you did not give legal advice? Yes, you did. Which is which? Did you give legal advice?
Yes, I can see Mr. Mulman is standing.
Oh, I'm so sorry, Mr. Mulman. Sorry,
Yes,
I was
Mr.
placing
Mulman.
away. I apologize.
Thank you, my lord. My lord, the witness has now rightfully answered this question a couple of times. He's not getting a different answer. Doesn't matter how he puts the question to her. I think at this point, Mr. Mpofu must accept the answer, perhaps.
No, Mr. Mulman is misleading the court with respect. It's not true to say the witness has answered the question and gave the same answer. We are all here, Mr. Mulman. The witness, I asked him at the beginning whether the thing included legal advice. She said yes. I asked her a few minutes later. She said no, she didn't give legal advice. I've just asked her now. She says, if doing all the things she described was legal advice, then yes, she did. So that's three different answers in the space of I don't know how long. So it's not true. It's definitely not true.
If I may just now simplify it, Ms. Sattler, firstly, you are given mandate to look at the Twitter. And thereafter, please, if what I say to you is not correct, say so. And thereafter, to advise whether that make a case for incitement or instigation. Is that still correct what I'm saying?
Yes, my lord. So the question is, did I give them legal advice? Did I say you need to go out and
All right,
charge?
let's park for them now.
Yeah.
And then after that, did you then give them advice or make conclusion whether there was a case for incitement or instigation?
Yes, my lord.
So, Mr. Mulman, I think then that answers.
As the court pleases.
Thank you.
Thank you. Thank you, my lord. I'm indebted to the court. And now, I honestly thought we had moved away from that because you have accepted, as you have just done now again. The only question I was now asking you, which was at another level, was having accepted that you gave legal advice, that's when I was doing those things, to the one side and not to the other. Would you accept that that is not the classical definition of independence?
No, my lord. If you look at the expert report prepared on behalf of the defense, who had exactly the same material available to him, he makes strong findings about how, beyond reasonable doubt, this person has been found not to have done this. What I've done in mine is I've concluded by saying it is my view that there is a case to answer. That's what I've done. So I've done an analysis of what content was available, an analysis of the law, and then I conclude by saying it is my view that there is a case to answer. It's not an instruction to go out and prosecute.
Did you say to this court, in relation to the material that you and I have accepted should be discarded from page 68 onwards. Did you say to this court that your intention of including that material
Yes,
was
Mr. Molman is on
I'm sorry,
this
sorry.
field. Yes, Mr. Molman.
I'm sorry, yes. Thank you.
Lord, my objection is based on the fact that these questions are not flowing from the court's questions as to the reasons.
Yes.
My Lord, with the greatest respect, that objection cannot be sustained because the only issue that the court probed with this witness was the nature of her mandate, to put it broadly. And that's all I'm asking about.
What question are you objecting to, Mr. Molman? You still remember?
I would. My submission was that the court has asked the basis on which she was instructed and the report she produced.
Yes.
But we're now venturing away from that, in my opinion.
So what question precisely that you are objecting to in order to assess whether it's...
My Lord, if my objection is wrong, then I will withdraw.
No,
Can
not
I just-
that. I've not made a ruling to your objection. I must be fair to you. I must understand where are you coming from. Because the matter arising is to do with the role of the witness in the investigation of this matter.
My Lord, if I can maybe just ask the court's indulgence, I just want my colleague was taking the note from me. I just want to get the question from you.
Yes, I just want clarity so that I should be fair to you as well.
Lord, I will withdraw the objection.
Objection withdrawn.
Thank you. Ma'am, since the objection has been withdrawn, I've really forgotten what I was asking you, but it has come back to me now. I was saying, ma'am, that now that we've settled the question, believe me, I won't go back to the issue of whether you give legal advice or not. You've now answered it to His Lordship. The only point I was now making, moving on, was that you gave that legal advice only to the one side of the equation. Would you accept that?
Yes, my Lord.
Thank you. The next question then is, or was, did you say to this court that the purpose of giving the material from page 68 onwards, which you and I had agreed could go to the dustbin, was in order to assist the investigators in making the decision? Correct? That was your evidence.
Yeah, my Lord, the case law I included very much with the anticipation that it would be useful if there was a prosecution to have international case law. The international case law in these areas is very important because these platforms are so new that we often have to rely on international law. And so that does fall within my field of expertise, given my work in this area.
Am I to understand that you included that part to assist the prosecution?
Yes, my Lord.
And that assistance, kind assistance of the research and international law, you did not extend to the accused, correct?
My Lord, I've never consulted with the accused. The accused has access to all of my material that was included in the docket.
No, ma'am, please, ma'am. please. I'm begging you. There was no docket at that stage. Do you understand that?
Yes, my
Yes.
lord.
So when you drew this document, it was not for the purpose of any docket or disclosure by the NPA and all those things happened in the future.
Yes,
You're
my
not
lord.
a sangoma.
Yes,
You didn't know what was going to happen in the future.
yes.
So, I'm saying to you, the pre-prosecution advice that you gave to the state and NPA and all those people, as this lordship explained on the stage, that assistance was not extended to the, shall we say, to the suspect, because she was not accused at that stage. Agreed?
Yes, my lord.
Thank you. And again, correct me if I'm wrong. You accept, or at least you have intimated, that the state was at fault, or maybe I'm putting it too high. The state should properly have come back to you to draft another document,
Yes, my lord.
and they failed to do so.
Yes.
And that document, which does not exist, would have been intended to assist the courts now, this time.
Yes, my lord.
And it will be different from the document which was intended to assist one side, correct?
My lord, as discussed already in this courtroom today, it would be identical, but for the inclusion of a statement of independence and excluding the case law, which would not be appropriate in a traditional expert witness statement. But pages 1 to 70 would be identical.
To 68. You remember you corrected me, you said it's not 70, it's 68.
I'm happy with 68. It's just those two high-profile Twitter suspensions that we
Yes.
exclude.
Yes. You see, ma'am, I'm going to argue that, and in fairness to you, I won't say maybe you're doing this deliberately. But it has a potential to mislead. You can't say this thing is identical to this thing, except that this one is a pen and this one is not a pen. Because that defeats your earlier statement. Do you agree that the non-existent document would have been different from this one?
My lord, I've answered this question about 7 times today.
And answer it for the 8th time, ma'am.
Pages 1 to 68 would be identical, my lord. It would be a copy-paste of what is in here. It remains my opinion. The methodology is in there. My CV, my experience is in there. All of the open source information which I obtained myself, I literally would have copy and pasted, my lord.
Okay, you've answered it for the 7th time, and I'm going to ask you for the 3rd. The document that we're talking about is 125 pages, correct?
Yes, my lord.
Do you accept that the document, as it stands here as one document, would have been different from the one that you'd have prepared for this court? Don't tell me in what respect or what respect. Do you accept that it would have been a different document? Or are you saying it would have been identical to this 125-page document?
My lord, I have answered this question many times.
Can you answer it again?
The fact-finding part of the document, which is page 1 to 68, would be identical, my lord.
All right, I'll give up. All right. Now, sorry. So, is your evidence then something like this? That the fact that the state missed the step of coming back to you once they now have made the decision to prosecute, they should have come back to you. You and I agree on that. So is your evidence that that missing of that step has no consequence?
My lord, I believe that my evidence is still of great value to the court, that it is still of the value of an expert, despite not meeting various formulaic, I don't want to say requirements because they're not requirements, but accepted practices. For example, the Statement of Independence. I believe that my evidence is still of great value to the court, given my expertise and my experience in this area. And ultimately, my lord, that will be a decision for the court and for argument. I've got no doubt it will form a big part of argument as to how to treat this report.
No, fair enough. But I just want to ask you, as someone who says you had distinctions in law, whether you have ever heard of an expert testifying in a court of law without an expert report. Have you ever heard of such a thing?
My lord, this document, as discussed, serves the purpose of an expert witness report. I maintain that despite the fact that the state missed the step of coming back to me to ask me to turn this into an expert witness report, it should still be accepted by the court, pages 1 to 68.
Perhaps that now can be done during address,
Yes.
whether the weight admissibility issue between both of you.
Yes. I accept that, my lord. I just want to say this, ma'am. I accept your lordship's guidance on this. That the day the accused person asks me to give a memorandum to weigh her prospects in the case, and I give her that memorandum. And then one day later, I expect the court to accept that as an independent expert report. Then I think that will be the day our law changes fundamentally. But that's fine, you don't have to respond to that. That's the part that His Lordship says will be left to the lawyers. Now, His Lordship also asked you about the last topic here. You talked about the deleted tweet. You remember that? And I just want to say one thing about the deleted tweet. It's the one where I agreed that your evidence was incorrect and exaggerated, correct?
My lord, the record will show exactly what I said.
Yes, Mr. Mulman is on his feet.
I think she should be informed what was incorrect about.
Thank you. I accept that. Your evidence in respect to the deleted tweet was that the accused had portrayed somebody shooting at Cyril Ramaphosa. Remember that?
Yes, my lord.
And when we went through the cross-examination, you had to look at the thing, and afterwards you accepted that that was incorrect.
My lord, what I accepted was that he was a bad shot. That was what we concluded. I accept that no bullets landed on the face of Cyril Ramaphosa on the poster, but I maintained my view that the shots were fired at the poster of Cyril Ramaphosa's face.
No, ma'am. That was, you can't, you see, that's how you mislead the court. You use the word maintain. Your original evidence was that the person was shooting at Cyril Ramaphosa.
Yes, and then we agreed in the cross-examination that shots were fired at a poster of Cyril Ramaphosa's face. And yes, I did accept in my cross-examination that no bullets were fired onto the actual face. But I maintained again and again that the poster was of Cyril Ramaphosa's face.
Ma'am, you know, you're making life difficult for yourself. Your evidence was that the person was firing at Mr. Cyril Ramaphosa, and that was shown to be incorrect. Did you maintain, as to use your word, your original evidence that it was firing at Mr. Cyril Ramaphosa? Or do you maintain it now?
My lord, I maintained it in my evidence throughout. I said again and again the fact that the bullets didn't land on a cheek.
Perhaps that kind of evidence, that will be dealt with when one way credibility, and because on that evidence, whether there were contradictions or not, perhaps that will have to be dealt with. Perhaps when you make submissions.
Fair enough. I accept that, my lord.
I still remember exactly what is on record.
Yes.
But
that's fine, my lord. I put it to you, ma'am, really to cut it short. We will deal with this in argument. I put it to you that your evidence in this respect now, today, is evasive and untruthful, because you know that you did change, once it was demonstrated to you by video and all that, you did change your evidence. But now you're telling us that you maintained it. The record will speak for itself. I'm just putting it to you. Right. I think, my lord. Oh, sorry. There is just one. I'm sorry, my lord. There's one little aspect. Again, it's this thing of how you use words. So you say, the only information I had was my investigations. That's what you said to his lordship.
Sorry, I didn't understand that sentence. Please say it again.
You said many times, both to my learned friend and to his lordship, that the only information you used for this investigation came from the tweets.
And articles that I reference in the memorandum.
Yes.
Yes.
Do you maintain?
Yes, I maintain.
Yes. Now, you know the word only means only. In other words, you use, those are the things that you used, and you maintain that.
Yes, my lord.
Yeah. But your own memorandum says that you had, you were given a USB by Colonel Nazo to do with what you have said is inseparable from this case, correct?
I didn't say it was inseparable. I said there was an interplay in the content.
Ma'am,
just now in this court, I said to you, I'll come back to your issue that you can't separate the two cases.
I said the original conversation couldn't be separated, but certainly the cases are separated.
Wow. All right. Again, the record will speak for itself. And then, if the cases cannot be separated, then why did you include it in this report of this accused?
In paragraph 2. I included it.
Right. Other thing is that tell the court the information, but there was also other information given to you by the NPA, correct?
Only the USB, my lord.
No, this is a separate USB. Again, there's one USB you're given by Ken and Nazo, correct?
Yes, my lord.
There's a different USB you're given by Warrant Officer Nzuza.
Yes, my lord. Those were the same. It was just included translations in the second USB. Only relating to the WhatsApp groups, nothing to do with the accused's case.
Yes, but it was a different USB.
Yes, my lord, I've explained that from the outset. It's in the very first part of my report. I was given a USB with the WhatsApp conversations. A lot of that content was in isiZulu, and I was given a supplementary one 2 months later with translations of the content on those WhatsApp groups.
Exactly. So then to sum it up, it is not true that the only information you had were the tweets and the research. The truth is that you have the tweets and the research, yes, plus the USB from the police, plus the USB from the prosecutors.
My lord, I do not rely on those USBs in this report at all. The only time I reference them is here in paragraph 2.5. And as I've said time and again, every piece of content that I rely on, I obtained myself. There is nothing in here from the WhatsApp groups.
Yeah, but you used that information to prepare the memorandum. Yes or no?
My lord, I reference the WhatsApp groups, I think, on 2 occasions where there's an interplay. So where the accused tweeted something that was very... I explained in my evidence in chief and in the cross-examination already.
Okay. Seaman, please, which is the truth? Just now you say, I have not used the information from those USBs in my evidence. Then I show you that you did. Then you say, well, it was only in 2 places. Which did you or did you not use the information from the USBs in the preparation of a memorandum?
My lord, I did, but it's not relating to the content of... What I said was that all of the content that I obtained that was published by the accused, I obtained myself. I have very clearly laid out the fact that I was given the USB with content, and where I have relied on content from that USB to show the interplay of the coordination on the WhatsApp groups, I mark it very clearly in my report.
Yes, I accept that, ma'am. You mark it clearly, you probably put stickers on it or whatever. My question is much simpler, and I'm asking it for the last time again. That you did use the information in the preparation of your report.
Yes, my lord.
Yes. So it is not true then to say the only information you used were the tweets and the research.
My lord,
the 2 statements can't both be true.
My lord, we're talking about different matters here. What I said was that all of the evidence that I obtained from the accused social media accounts, I obtained myself. That is what forms the basis of this report.
All right, I'll leave that for argument as well, but that's not what Your Lordship asked you, and that's not what I had asked you in the morning cross-examination. But we'll leave that for evidence. We'll accept your latest answer. My Lord, I'm indebted to the court. Those are the questions that arose from Your Lordship's.
Thank you, Mr. Bob. Mr. Mulman, anything arising from the court resolution?
Court's questions.
Thank you. Ms. Sattler, thank you for your time.
Thank
You are
you.
now excused. You may stand down.
Thank you, my lord.
It's now 8 of the afternoon. As indicated, changes should be available tomorrow morning.
Yeah.
My current request would be to hold this matter until 10 o'clock tomorrow morning to witness is starting from Victoria. Flying in the morning early. So we can mention until 10 o'clock before 30 minutes.
Yeah.
My Lord, yes. My Lord, I have no objection to the adjournment as it was discussed earlier till 10 o'clock tomorrow for the purposes of calling what my learned friend has assured me is the last witness. I won't hold him to that, but I'm just recording what we discussed.
Yeah.
My Lord, on the basis of the fact that that witness apparently is only traveling in the morning, I would normally have asked us to start early, so 10 o'clock. My Lord, this is something I want to say. And what has changed now, because it might have implications, but I'll address that tomorrow. For now, I don't have any objection.
Thank you. Ms. Zuma-Sambudla, you may stand up. Your matter is enrolled over to tomorrow for further hearing. You are released on warning. You come back tomorrow at 10 o'clock. Court will adjourn. Court over.
Ja, maar gewoon